Hello, and welcome to the second lecture of the JGLS Public Lecture Series. Today's lecture is where we left off yesterday in terms of cross-border insolvency and the European cross-border insolvency law. I'm particularly excited for today's lecture because today's speakers come from a wealth of experience on cross-border, which is Germany and France. As the title suggests, that's the case study that we're going to be doing, and have also worked very closely with different European jurisdictions in different transactions and cross-border restructurings and insolvencies. To introduce the first speaker today, we have Dr. Robert Hainer, and a special thanks to him because he's the reason why this lecture series has become possible. Now, to not go over too many of his accolades, I'm going to keep his introduction brief. And given that we live in a Google generation, I know a lot of you would have already looked up both our speakers in detail. Dr. Robert Hainer, as I said, comes from a wealth of experience in terms of insolvencies and restructurings. He has been a court-appointed trustee and insolvency administrator in Germany, and is presently the partner of Anchor, where he continues to have regular appointments as a trustee and an insolvency administrator and a custodian by local courts in Germany. Now, moving on to our second speaker, which is also a very exciting individual to have here, is Méline Baucher-Robinat. Méline is a partner and a co-founder of Baucher-Dobel, which is a law firm focused on restructuring and insolvency in Paris. It is incredible to have her because a lot of her writing material has become a part of my teaching at the law school where I teach, which is in the Global Law School. Now, Méline comes again from a wealth of experience. She assists mid-market and international companies in the context of restructuring and insolvency proceedings. She has represented extensively in German and English disputes, and has represented several creditors, investors, and insolvency officers. Now, I want to give you a very brief insight into how we're going to pan out this lecture. We're going to start with a very brief introduction of the German and French local insolvency regimes, and then get into a case study, which is going to form the basis of how cross-border, which is Germany and France, interact with each other, with their local laws, and the EIR, which is the EU's cross-border law. Now, without further ado, I'm going to hand over the floor to Robert, who's going to take us through the German law. And after that, Méline is going to give us an insight into the French insolvency regime. Over to you, Robert.
Thanks a lot, Ishana, for your kind exaggerations. Now, I'll give you a very brief overview of some highlights of the German system. At least the features which are, I think, most interesting for our session today. What you need to know about the German system is that there is one uniform insolvency proceeding. We don't have different insolvency proceedings for restructuring and liquidation. It's just one uniform proceeding with the aim to get the best result for the creditors. I will not talk about the newly invented pre-insolvency regime that we had to invent on 1st of January 2021 due to European law. I'm only talking about the insolvency proceeding, and in particular the office holders and the players in that proceeding. Now you have an application for an insolvency proceeding, you have later on opening of proceedings, and then the final termination of proceedings. And if there is need of any securitization measures in the time between filing and opening of proceedings, then there will be a provisional insolvency proceeding. After opening, you have final insolvency proceedings, and during that part of the proceeding, there is a possibility to submit an insolvency plan, and both may lead to liquidation or restructuring. An insolvency plan is a tool to just do it differently to the regular proceedings. It doesn't need to be restructuring, but most of the times you use insolvency plan proceeding for restructuring. After termination of the proceeding, if the debtor is an individual, a natural person, you may have discharge proceeding so that in the end, the debtor gets a discharge of the residual debt. Now, as for the court, you have two persons involved on the side of the court, and one is the insolvency judge, and he is responsible for the opening proceeding. So between the application and opening of insolvency proceedings, you have the judge in charge. And judges in Germany, they have the same education as lawyers. They make the same exams, so they are legal persons. You may note that for later on when Mylène talks about French judges. In case that there is an insolvency plan proceeding, the judge is also responsible for the plan proceeding, because there you have cross-class cram down possibilities and things like that. But apart from that, you only have a registrar of the court who monitors the proceeding. And the court doesn't play a very active role. So in particular, the insolvency administrator doesn't need the consent of the court for any important measures during the proceeding. He may need internal consent by creditor committee, if there is one, or by the creditors assembly, but not by the court. The court is just monitoring the proceeding and look that everything is in order. You can have the proceeding both as a regular proceeding, as we call it, and as a self-administration proceeding where the debtor stays in charge, like a debtor in possession proceeding, which you have in most of the country. Meanwhile, in particular, it's the Chapter 11 proceeding in the United States, which is most famous for it. And if you have self-administration on the debtor's application, the provisional insolvency proceeding will be a provisional self-administration. And there we borrowed a term from the French. It's a safeguard proceeding. That is a special form of that preliminary self-administration. Now, the most important part for the insolvency court and the judge is to appoint the office holder in the proceeding. And after you have an application, normally the court will appoint an expert to check whether the preconditions to open insolvency proceedings are met. And the time between application for the proceeding and opening of the proceeding may take up to a couple of months. That is, the reason for that is that you can pre-finance the wages of the employees, but that would be another topic. As soon as we have securitization measures, the court appoints a provisional insolvency administrator. And the court also orders the tasks and the powers of that provisional insolvency administrators, and they may be different, and it's quite flexible. After or upon opening of insolvency proceedings, the court appoints the insolvency administrator, and the insolvency administrator has the full power of disposal over the debtor's assets. And so he can do almost anything. Of course, he is liable and responsible, he has to report and everything, but he has the full power to execute all powers the debtor would be able to execute, and in addition to execute additional insolvency-related powers. He also examines the claims which the creditors may lodge during the proceeding. In a self-administration proceeding, you have, instead of these provisional insolvency administrator and insolvency administrator, a provisional custodian and a custodian. And they have mainly the same role, which is monitoring the proceeding and looking if the debtor makes everything correctly. And if he doesn't, then they ring the bell to the court, and the court may then change to regular proceedings if the debtor doesn't perform correctly. But apart from that, the custodian only has a monitoring role, and he has particular powers with regard to insolvency-related claims, like clawback claims or holding the former directors liable. Those powers are with the custodian, but apart from that, the debtor is in possession and administers the whole proceeding. During that discharge proceeding, you have a trustee whose only job is to collect the debtor's seizable earnings and distributes among the creditors, and that's it. And with regard to supervision, you have the creditors' assembly, you have the insolvency court, and you may have a creditors' committee who supervise and monitor the insolvency office holder. And in the discharge proceeding, you only have the court to monitor the trustee. The creditor's role can be quite important. They have a lot of powers. They can decide about whether to liquidate or to restructure. They can elect a new insolvency administrator if they are not happy with the one the court has appointed. But they often don't make use of their powers, in particular in proceedings where you don't have lots of assets and it doesn't make sense economically to participate actively for the creditors. So that's it mainly for the German proceeding. Very simple, very straightforward. And I hand over to Milène.
Okay, thank you. I will share my screen too. Let me just take it. Okay. So now the French insolvency regime. Can you just see the slide? Is that okay? Yeah? Okay, good. So France. So France and Germany neighbors countries, but actually the insolvency and restructuring laws are very, very different. We are both civil law regimes, but you will see in a minute. Our regime has few to do with the German insolvency law, although our objective, our aim is to narrow the law, and it would be great for us that France and Germany, French and German regime would be much more harmonized and be the core of the future unified European insolvency law. But it's not for tomorrow, but I guess we do a lot of things, a lot of projects in order to have our both insolvency regimes become narrower. So in France, as contrary to Germany, I would say, we have a much more debtor-friendly regime. Which is that the purpose of insolvency law is to protect the interest of the debtors, ensuring the continuation of the activity to the extent possible, and the preservation of employment. Employment is a key issue for France, and especially in the context of restructuring and insolvency proceedings. Actually, another feature of French insolvency law is its preventive nature. It means that the French legislator, has always tried to give incentive to the debtor to take measures at the earliest stage possible when the difficulties of the company, of the activity, are relatively little, okay? And the sooner you take measure, the better the restructuring solution can be as a matter of principle. So that's why in France, we have created different preventive measures, which are preventive proceedings. But now I come to this table. I will not go into the detail of all of this proceedings, but I just to use this table in order to let you know. Sorry, can you see the table? I'm not sure this is the right.
If you could just expand it, maybe. Yeah.
Okay. Yeah. Is that better?
Yeah, better.
Okay. Okay, good. Here it is just to let you know that that you have many different restructuring and insolvency proceedings. Robert explained earlier that in Germany you have one insolvency proceedings with different processes within this proceedings. In France, that difference. You have many different proceedings, and we call it the toolbox, la boîte à outils, the toolbox, in which you can pick and choose, and choose the proceedings which are the most appropriate to answer your needs. And basically, we make a distinction between preventive proceedings on the one hand and collective proceedings or formal proceedings on the other hand. Okay? Preventive proceedings are mandat ad hoc and conciliation proceedings. And collective proceedings are our safeguards. There are many different safeguard proceedings, rehabilitation proceedings, and liquidation proceeding. I just let the French names here. So preventive proceedings have existed in our systems for a long time, as contrary to Germany, which have had to introduce that kind of preventive tools because of, or thanks to the directive, the European directive, we already had this procedure for a long time in our system. The main difference between these two categories, these two words, I would say, are the fact that preventive proceedings are amicable proceedings and confidential proceedings, whereas collective proceedings are public proceedings and judicial proceedings. Okay, the difference between these two words is not the insolvency, the state of insolvency, which is pursuant to French insolvency law, the cessation of payment, which is a cash flow test. We only have a cash flow test in France. So here you can see it better. The cessation of payment is not the distinction between preventive proceedings and formal collective proceedings. This is just one criteria in the choice of the proceedings, but you just need to believe that those amicable proceedings are not made for solvent debtors only, whereas an insolvent debtor has only collective proceedings available. The main distinction is that here, if you have any chance to find an amicable restructuring, an amicable solution, an agreement with your main creditors, then preventive proceedings are made for you. And it is much better because it is confidential. No one except your main creditors are aware that you are under a restructuring process, including your suppliers, your clients, your employees. So it protects the value of the activity of the debtor. Okay, so better. It consists in the appointment of a third-party mediator, a mandataire ad hoc, or a conciliator, who will assist the management to define and negotiate a restructuring agreement with the main creditors. Basically, that's it. collective proceedings that has nothing to do. This is, closer to what Robert described. So formal insolvency proceedings with the rules we know everywhere in the world, I would say, suspension of enforcement action, a freeze of payment, appointment of an insolvency practitioner, etc., etc. These are collective proceedings and they are public. But there are different types of proceedings, and here you can see in yellow, orange, our safeguard proceedings, which can be considered as a preventive proceedings because it is made for solvent debtor only. These are debtor in possession proceedings, so as maybe closer as what you described, Robert, with your self-administration proceedings. And the purpose in these proceedings is to find a restructuring agreement in the sense of a rescheduling of the debts. There is no sale of the business possible, or the main business. Okay, the debtor remains in possession, and the shareholders is sure that he will or it will not lose its business. Okay, and then you have traditional rehabilitation and liquidation proceedings, where they can be a sale of the business as a going concern, of sale of the assets piecemeal, if no restructuring of the company is possible. That's it.
Thank you so much for that brief but yet comprehensive insight, Robert and Maylene. Now, in this background, we're going to go over a fact pattern, which Maylene is going to take us through, and we're going to delve into certain questions which I'm going to raise, and they're going to respond to in the background of that fact pattern. So, Maylene, over to you.
Okay. Up. Just very, very, very briefly, so I will just give you the main lines feature for our case study, French-German case study. So we will take the example of a German law company having his headquarters registered in Germany, in Munich. Okay, we will call this company German Corp. This is not really a German name, I would say, but it is just for your understanding. So German Corp is a German company whose seat is registered in Munich in Germany. But this company also has business activities outside of Germany, and especially in France, through establishment. And the first establishment is located in the south of France, and this is the factory. So where the goods of a German Corp are produced. There is the plant over there in the south of France. There is another establishment, other activity located in Paris. This for all commercial activities, development of the or sale of the products, especially in France, but also throughout Europe, and also R&D activities in Paris. Just one comment, just be aware, this is one unique company, okay, having its headquarters in Munich and establishment in France. These are not subsidiaries in French, only establishments, okay, belonging to the same legal entity. There is one legal entity, German Corp, having business activities at the same time in Germany and in France. So this is our case. Now, I let you the word again, Shanna and Robert. One question, do you want me to keep this here or?
Well, I don't think it's necessary.
Okay.
Now, in this fact pattern, Maylene and Robert, I want to raise the first question, which is the cross-border law, which is the EIR recast. Now, explain to us in the fact pattern of having a German establishment, a French establishment, and a seat in Germany, how does the EIR come in handy? And why has there been resistance to the UNCITRAL cross-border law, and how do these two interact?
Okay. Now, the EIR, the European Insolvency Regulation, was introduced in 2000. There was some resistance before because of English mad cow disease. When Europeans didn't want to buy English cows anymore, the English ones didn't want to agree with the regulation, but then it was introduced. And it is a bit more sophisticated set of rules than the model law, which governs mainly all European member states. And the insolvency regulation says which court is competent internationally, and that is according to the COMI principle, center of main interest. That's more or less the same like the model law. It says that you have automatic recognition. So if one insolvency proceeding is opened anywhere in the EU member states, it's automatically recognized in the other member states, as well as all decisions within that proceedings are automatically recognized without any recognition proceeding. And in addition, the powers of the insolvency administrator and maybe the powers of the debtor in possession they have within the proceedings are also automatically recognized within the other EU member states. Then you have a set of rules about which law is applicable for what kind of action and some limits. And now we come to the main feature of our case study. You have regulations about different proceedings in different countries. You can have two situations here. If you have a group of companies, you have insolvency proceedings for the different members of the group. But in our case, the question is, can you have more than one insolvency proceeding for one legal entity, for one debtor, as Milene explained? And that is possible. And the concept of the European Insolvency Regulation is that you have one main insolvency proceeding. So like Catholicism or Christianity, only one God, only one main proceeding in Europe. And all other proceedings can only be secondary proceedings. And they only have a territorial effect. So they're only effective on the territory of the country where secondary proceedings are opened, while the main proceedings has a universal effect and is recognized all over all EU member states. So that's the main difference. And in our case, if everything goes according to the rules, main proceedings would be opened in Germany, because there you have the seat and the headquarters, the registered seat and the headquarters. And if you have that in one country, then there is a presumption that the center of main interest is where the registered seat is. And then for the establishments, and there is a definition about what is an establishment, you can have secondary proceedings in France. Now, the difference, why does Europe, or why do European countries don't need the model law? Because among themselves, the European Insolvency Regulation applies, and it covers everything the model law also covers, and even more. And in some aspects, I think it is more handy than the model law, because you don't need any recognition proceedings. Of course, if you have insolvency proceedings outside the EU, then the European Insolvency Regulation does not apply, or not necessarily apply. And then the question is, what kind of national, international insolvency law do the different countries have with regards to recognition of, let's say, an Indian insolvency proceeding? And there are big differences. There you may have countries in the EU which have adopted the model law, and then according to the model law deal with those foreign proceedings. And you may have other regulations. And in Germany, it's very easy. And the reason for that is that the EU regulation was drafted by a German, And so he just blueprinted that and took it into German international insolvency law. So basically you can say what applies for other EU member states also applies for the whole world if you come to Germany. So it's very easy to get recognition or to act in Germany for a foreign representative.
Now that's very interesting, and I want to just tilt over to France, where both civil law jurisdictions, right? But the response will be pretty different if we were responding from a French perspective. So, Maylene, over to you.
Yes, sure. I mean, the answer for French with respect to the recognition of proceedings out of the EU will be different. As Robert said, if an insolvency procedure has been opened in an EU member state, in France, we have to recognize the opening of such proceedings and its effects pursuant to the law applicable to this insolvency, which is the lex fori concursus, the law of the state, the opening state, okay? We have to. This is a rule of our insolvency regulation. However, if the proceedings have been opened outside of the EU, then it is common law, international private law of common law, not European law, which is applicable. And in that case, this is the simple exequatur process which has to be made. So basically the debtor or the foreign insolvency practitioners has to make an application before a French court in order to have the foreign but non-European insolvency proceedings recognized in France and therefore having its effect in France. Ishana, may I just make a comment to what Robert said? Because Robert said that for our case today, then we would have the main proceedings opened in Germany because the headquarters are located in Germany. And there is a presumption that the headquarters are the center of main interest, so where the main proceedings shall be applicable. But this presumption is rebutable, meaning that it's not necessarily the case. We will take this assumption later for our case study, where main proceeding will be in Germany, where we have the headquarters, and secondary proceedings in France, where we have the establishment. But it's not necessarily the case. You can actually interpret, define differently the center of main interest, and it could be possible that a French court, for instance, a French court would consider that the center of main interest is not based where the headquarters are in Munich, where they are actually in the south of France, where we have the very big factory. This is where the debtor has its main activity and where the main proceedings should be opened. They also could consider that actually it is in Paris because this is where the administration, where the main managers are, decisions are taken in Paris. The R&D center is a very big center. So actually you can see here that there is a room for competition, for forum shopping inside the EU, although the European regulation provides clear rules for this main and secondary proceedings. To my experience, I do not know cases in which we have had litigation between France and Germany for a court having jurisdiction for the opening of main insolvency proceedings, but it happens with other member states, yes.
That's quite an interesting take, and I know Robert wants to respond to that because, but say you have an Indian creditor, right? That is France, then it would seem is a friendlier regime than Germany, to be able to enable a cross-border proceeding outside the EIR. Would that be a correct assumption to make based on German civil procedure and the French insolvency regime vis-a-vis recognition? If not, if that is not the correct assumption, then how would each country react if there was an Indian creditor or say another Indian subsidiary that was involved out of the EU jurisdiction?
Well, I assume that we disagree on that question, Milen and I. I would say for creditors, the German insolvency system is always much more attractive because you don't need any recognition. And the aim of German insolvency proceedings is to get the best result for the creditors. Whereas the aim of the French proceeding is to restructure and get the best result for the employees. So you might have noticed that the French system of insolvency proceedings is like a spiral of horror. It gets worse and worse for the creditors. And so they are willing to agree to a restructuring in an early stage because it can only get worse. In Germany, insolvency proceedings may be quite attractive for creditors because they have an influence, no problem about recognition. It doesn't matter whether you're a foreign creditor, domestic creditor. I even have a case where a foreign creditor is a member of the creditors committee in a German proceeding. So German proceedings are absolutely attractive, but I'm waiting for Milen's response now.
No, I absolutely need to answer that the French insolvency law is not a nightmare for creditors. But I have to admit that it is a debtor-friendly regime. But actually, the French legislator has introduced many reforms in order to find a new equilibrium, a new balance between the rights and interests of the debtor and the ones of the creditors. And now creditors have many more powers in our formal proceedings, such as, for instance, they can make suggestions, suggest the restructuring plan, and have this plan submitted to the vote of creditors committees. So we take into account the interest of creditors, but that's fully right. Actually, as compared to Germany, the main decisions related to the proceedings are not taken by the creditors. I know that in Germany, you spoke about the creditors committees. Robert, big decision about the solution, the plan are submitted to the vote of the creditors committees. In France, the main decisions are taken by the court, by the insolvency court or by the insolvency judge. But for instance, decision about the nature of the procedure, safeguard, rehabilitation, liquidation, is made by the court. Decision on the plan, actually there is a vote of the creditors or a consultation of the creditors, but at the end it is approved by the court. And moreover, the sale of the business is decided by the court. The buyers, the potential buyers, they make offers to buy the business as a going concern, and the name of the buyer is chosen by the court. So yes, I would say, for instance, just let's think about hostile proceedings, proceedings open upon request of creditors. I would guess that a creditor may be more attracted by requesting insolvency proceedings in Germany as in France.
So this kind of gets me to the question on forum shopping and creditor rights. Let me just do a little bit of a recap here. Now, France, while it might mostly be a debtor-friendly regime, there has been, as you rightly pointed out, an equilibrium that has been reached, right, where a creditor can suggest a restructuring plan, for instance. And Germany, very interestingly, Robert, in our discussions, we've noticed that other parallel proceedings are frozen in the event that against a corporate debtor, right? And if insolvency proceedings are open in Germany. Now, in this kind of context, talk a little bit about what would happen. What is the impact of having parallel proceedings against a corporate debtor in a jurisdiction that is not within the framework of the EU? I know there is an enforcement recognition question that we've answered, but this question is mostly on communicating between courts and how that works. If you have an example where you can pick up the phone and call another court, which was an example that I heard recently in a UK France case study, where they just picked up the phone and said, okay, we will not proceed with proceedings that allow a petition on insolvency. Will that work in a regime such as Germany, where there's a blanket freezing of parallel proceedings, or in France, which in general has looked at conciliation as opposed to litigation, right? Or restructuring, for instance, within its legal regimes?
Okay, now there are several possible scenarios which you could go into for that. Let's just briefly go to the scenario that you have litigation anywhere and then you have an application for an insolvency proceeding. I don't think that there would be any communication with the court that is competent for the litigation and the court that is competent for the insolvency proceedings, because there are automatic effects if insolvency proceedings are opened on the litigation or not, so that it's not of much interest for the insolvency court. The interesting situation is when you have applications for insolvency proceedings in different jurisdictions, like a creditor applies in France and the debtor applies in Germany, or we also had the case that the debtor himself applies both in the UK and in Germany. And then you have the situation that the judges know of the other application or they don't know of it. And if they don't know, you may have two opening orders for main proceedings, and then you have to battle about which one is really the main proceeding. And for that situation, the recast of the EIR introduced a remedy where in particular you can challenge a court decision of opening of main proceedings and say, no, this is not where the COMI, the center of main interest, is, so you don't have international jurisdiction for main proceedings. And then you can battle about that. But you can also have the situation that the courts know of each other prior to deciding upon the application. And then it mainly depends on the judges who are in charge whether they communicate or not. One issue is the language barrier, because you may not have all judges speak English or French, or let's have a case in Poland that would make it quite different. And not everybody speaks English. So that is kind of where the judges may be reluctant to talk to each other. But if they talk to each other, they can, of course, pick up the phone. I think it's not the case in Ireland, because in Ireland everything has to take place in a court hearing, but other judges can pick up the phone each other, go through the case and say, look, okay, we agree that main proceedings should be here. And then they kind of agree on who takes what decision. They may also come to a non-agreement. I've noticed that within Germany as well, where there is a battle between the competent courts, where different regional courts say, I'm competent for the proceeding, and the other says, but I'm competent, and then you have to decide on a higher level of the courts. And in our case, if the courts don't agree and both open main proceedings, then the European Insolvency Regulation says the one who comes first with the main proceeding is the one who prevails, except that it's challenged, and the challenge is successful in the end.
Yes. To add, just to react to what you said, Robert, about languages. for people in India, where I know you everybody talk perfectly English. Maybe you cannot see that, but from a European perspective, language is a key issue. German people also speak very well English, but you know, in Europe, I think I heard that yesterday at the conference with Christoph Paulus. I think he say that there are 17 different languages. Maybe I'm wrong, but that can be that kind of number of different languages. And so the main issue in coordination, cooperation is talking to each other, understanding each other. Yes, the language is a barrier. You need to have people speaking either the language of the other country or at least English. Okay. And next to that, or beside the language, then you need to understand the difference in the regime, because this is also another language. When an insolvency practitioner in France will talk about the court as taking decision, maybe the German insolvency practitioner will not really understand this, because in Germany, the creditors committees take the decision. So if you do not understand also the discrepancies, the main differences between our regime, this is very difficult in practice to have a very good understanding, communication, cooperation among court insolvency practitioner.
Now, what the court probably would do in Germany in that situation, I showed on my slide that after an application, the court appoints an expert to check whether the preconditions are met for opening of insolvency proceedings. And the court may also say to the expert, please check whether this is main proceedings, and please take over the communication with whatever other court in other countries is also involved in that proceeding for the debtor. And so the court will delegate communication probably to the expert.
Yeah. Ishana, do you want me to describe the rules pursuant to the insolvency regulation in our case?
Right, Milene, I was getting to that. But before that, I just wanted to kind of stay with this discussion on 2 points. Number one is obviously the kind of judge, which both of you have kind of stressed on. And I found it very interesting that the French regime actually has businessmen as insolvency administrators. And I want both of you, whereas that's not the case in Germany, and I want both of you to sort of weigh in on what is the expertise that comes in to the insolvency administration and court practice, very briefly for the listeners. And the second aspect is the harmonization aspect that both of you spoke about, and one being that of language. Now, in India, I think we have about 122 official sort of languages, and the language of the court is English to bring about the harmonization. And this is not counting other languages, which I think are in thousands. So where do you feel that kind of connect plays out in harmonization when you're looking at court-to-court communication and insolvency proceedings? And Christoph's lecture yesterday very specifically harped upon globalization, right? We have to be placed in a situation where creditors of different jurisdictions agree that, okay, we will proceed only in France. Yeah, how does that happen? And it is important for us, number one, to know what are the different kinds of insolvency administrators. Number two, how is it that we sort of agree to congregate in one place when there are jurisdictions who promote forum shopping, right, for better remedies, like Singapore, for instance. Yeah. So let's just stick with that, and let me get a response out of you on both these aspects. Milene first, and then Robert.
Okay, thank you. So with respect to the judges, this is one of the big difference between France and Germany. In France, the insolvency courts for business, commercial businesses are the commercial courts. And judges in commercial courts are not professional judges who have made studies at the university and make their whole career in courts. They are businessmen or former businessmen, retired businessmen. And I think that this system is very, very pragmatic and efficient, successful. The decisions are pragmatic. The judges have a very comprehensive and precise understanding of the business issues, financial issues, mechanism of big groups, for instance. So this is absolutely key, to my understanding, in the success of our insolvency processes. And they are also they do also play a role in preventive proceedings, even if I say that it is much more contractual, but there is a sort of control of the insolvency judge. He can take some decision. He can the judge or sometimes the court can make a stamp over the restructuring and approve it. Yeah, this is our system in France, businessmen instead of professional judges. And just also, as I told you, the court has a lot of power in insolvency proceedings, and my impression is that actually this is very prestigious to be an insolvency judge, at least in big courts where you have specialized chambers for insolvency proceedings, safeguard proceedings, preventive. Even judges, they only do or almost do only preventive proceedings, and this is something that judges like, I would say. This is something really interesting with adrenaline, I would say. Actually, I leave it with adrenaline, and I think they have it because it is really often emergent issues, cases in the press, national press, local press, whatever. It impacts employment and business, so it's important issues. So this is prestigious. Insolvency proceedings are a topic which is prestigious, I would say, for judges. And I know it's different, or it can be considered as different in Germany. Is that correct, Robert?
Totally correct. Now, that's a very good concept, I would say, and it fits, of course, to your system that the court decides a lot of things in the proceedings. In Germany, insolvency proceeding is historically regarded as legal stuff, like it is a collective execution of claims. And so it's traditionally lawyers who get appointed as insolvency administrators. Of course, those lawyers will have like learning on the job experience with economics and stuff like that, or maybe they even have second exams. But in the courts, you only have regular judges who start maybe at a prosecutor, then they do a criminal judge work, then civil law, civil court, and then they enter insolvency court for a couple of years, and then they go back to the criminal court. And so the experience legally may be good, not so much in insolvency law maybe, but some of the judges can't even read a balance sheet. And so it doesn't make much of a difference regarding the decisions they have to make, except for insolvency plan proceedings where they should understand what's going on in a restructuring plan. And this is something we have to work on in Germany. You do have judges who are really very good, who know the business and everything, but they're all legal persons. And just one more thing to mention. In Germany, insolvency administrators, as I said, don't have a special licensing. They are quite good prepared, but in principle, everybody can apply to become an insolvency administrator. While in France, they have a very sophisticated licensing system where you need legal studies and studies in economics and pass difficult exams to become an insolvency administrator. So it's much more economic focused and restructuring focused than in Germany.
You know, that's a very interesting sort of different take, because one of the things that India has introduced is, for efficiency, is actually time, you know, and to know that the efficiency of the proceeding can be enabled by the member or the insolvency administrator, and it can still happen in a swifter fashion, is a very interesting takeaway for a jurisdiction like India, which is now tinkering with its insolvency law and responding to the COVID-19 pandemic that that the entire globe is sort of facing. And being mindful of time, I want to sort of focus on, as a parting shot, on how both Germany and France have reacted to the COVID-19 pandemic and the restructurings and insolvencies. For instance, in India, the insolvency law last year in March was suspended for all new filings and admissions. And that still continues as we speak, and for another, I think, 15 days or so. So talk to the audience a little bit about how each jurisdiction has reacted, and has it impacted the efficiency of the insolvency process, and where do you see it going?
So maybe I start briefly. Germany hadn't had a very creative reaction, not more creative than all the other countries. There was a lot of money pumped into the economy for companies in need. We have a special system where you can send your workers home, and a special part of the state will pay for the workers and stuff like that. And as for insolvency measures, the obligation to file for insolvency was suspended. At first, there was a quite broad suspension, and then it was narrowed down only to one particular reason to file for insolvency. And in the end, at the moment, we still have a suspension, but a very limited suspension, only for a limited number of debtors who apply for it. But it's become so complicated that everybody thinks it's suspended for everybody. And so nobody files, and we have very few insolvencies. One of the political problems is that we have election year this year, and the politicians don't want to have applications for insolvency proceedings, even though it may be better for a lot of companies to apply for insolvency proceedings, because in fact, there are a lot of companies insolvent. We're talking about those zombie firms, which now exist only on state money, and they don't have a viable business anymore, and they should file in order to save something, but they just don't do, because everybody, of course, is very reluctant to go to the insolvency court, and that's a big problem.
Yeah, so in France, basically, we had the same set of measures with money injected in firms through mainly loans guaranteed by the state. All of this actually is ruled by European rules, competition rules. So that's why the mechanism, the measures put in place in Germany and in France are rather similar. I just would like to give a few words about the freeze of duty to file, because duty to file for insolvency proceedings, of course. We had some discrepancies among EU member states. And for instance, some member states, such as the UK, have decided to let their regime unchanged, so with a duty to file. Some other countries, such as Italy, have decided to freeze completely the filing. So as I understand, as in India, no possibility anymore to open restructuring and insolvency proceedings. And in France, between March and August 2020, we had an in-between regime where actually debtors, insolvent debtors, did not have any duty to file, but they had the possibility to do so if they consider that it would be more appropriate for preserving their business, okay? Especially as, for instance, the rules applicable are not the same. You can have a freeze of payments, impose it to your creditors. You can have wages advanced by a state insurance organism. So that's why we continued to have insolvency proceedings open in France in 2020, but with a very high decrease in the number. I understand between minus 40, minus 35% of proceedings, insolvency proceedings open in France, which is absolutely huge. And these firms, I mean, this is something problematic. Actually, it was the purpose of the government, you know, to avoid insolvency, to give money to the businesses in order for them to survive, you know, to wait until the economy will recover. But as Robert said, some of them are only zombies, some of them will never recover. And I would say, yeah, many people expect an increase, even a wave in opening of insolvency proceedings. I'm not sure about that. There will be a wave. It will depend on the capacity of the state to very progressively erase the protective shield. And I think this will be key for us with respect to insolvency proceedings in the future. Yeah.
Those are two very powerful thought processes, because it is not as if, you know, they're just developed regimes are sort of ready to, you know, swing back in. We're looking at insolvency being the next important step. We're looking at cross-border outside EU interactions being necessary as well. And this lecture has been very helpful in putting into context what we were talking about in yesterday's lecture as well, where are we looking at country-specific cross-border treaties or conversations, or in terms of different businesses and you know, different kind of relationships. And that's something we're definitely going to have to wait and watch, you know, from each regime. So this has been extremely insightful, and I'm very grateful to our viewers and the two of you to join us in this kind of conversation on how two different jurisdictions interact with each other from a cross-border perspective, and how they interact with the jurisdiction which is not a part of the EU framework. And I'm hopeful that the audience will stick with us next week as well, as we talk about two other jurisdictions in the UK and Singapore. And with that, I want to say thank you very much to both of you. This has been absolutely fantastic. And I hope to have you back again every semester for a lecture.
Thank you very much. Thank you, Ishana and Robert. It was an honor. Hello in India. It was a pleasure for me.
Bye-bye. Good evening.
Bye-bye.